Saturday afternoon, morning, or evening, depending upon where you are in the city. Welcome to From the Halls of Justice. And thank you. We have my colleague and partner, murvet Arnstein, with us.
Hello.
And the other producer. And for our special guest today, we have with us Mr. Daniel C. Hales, all the way from Orange County. And you're Orange County and LA County, because you're Irvine, Newport Beach, Beverly Hills. And he is the president of Citadel Law Firm. And he has a JD, an MBA. He's a certified estate planner and a CPhD. And our topic today will be protecting the family legacy. So he's an expert. And Murvet, do you want to take off with this?
Well, Dan Hales, Mr. Hales, welcome back to our show again. It's so nice to have you.
It's great to be here. Thank you for having me.
Sure. My first question is, we've heard about the dangers of not having any estate plan. Specifically though, what are some of the problems that could occur to a family without an estate plan?
Well, I think the important thing is to understand what an estate plan is. An estate plan consists of a lot of different kinds of documents that can protect one's health care while they're alive, and when one passes away, or if one becomes incapacitated, the estate planning documents can determine who's going to be in control of the assets. So there are a lot of different problems that can happen. Without the right estate planning document, you could end up stuck on a life support machine, having artificial life support for years, like Terry Schiavo in Florida was on a machine for nearly 16 years. A very simple document could have prevented that from happening. Or another big problem is probate. People that pass away without estate planning documents may have their whole estates, their house, their businesses, their bank accounts go through the public probate court. And that can be very costly. There can also be a myriad of different types of taxes that can affect one's legacy and cause the family to have to sell assets or liquidate things to pay the IRS. So loss of control, unnecessary taxes, probate, perhaps health decisions that aren't being made properly. All of these things can be problems without a proper estate plan.
Well, probate sounds like it's quite expensive though. You know, how long can assets be tied up in a probate court?
Well, the longest probate that I'm aware of in California history was close to 75 years.
Wow.
That's quite a bit of time. The average probate, however, is usually 2 to 3 years.
75 years?
I mean, you take an estate like Marilyn Monroe, for example, an estate consisting of a lot of intellectual property and royalties that are being fought over in a public court by various heirs and people who claim to be heirs, and then you get lawsuits involved, and probate can take a lot of time when you're letting it wind its way through the public court.
Well, what's the best way to avoid probate then?
Well, a living trust is the best way to avoid probate. You form a living trust, you name beneficiaries on your trust, then you transfer all of your assets into trust, and then when the person passes away, all of the assets go immediately to the designated spouse or children or grandchildren or loved ones, and it doesn't have to go through the public probate court. So it will save.
It's a good thing.
Yeah, it's a very good thing, and it's truly the best way to protect one's legacy is to have a living trust. Go to an attorney, get it created so that it does exactly what you want it to. You can always change it, you can always revoke it. If somebody gets out of line, if one of your children is not nice to you, you can always disinherit them or reduce their share. I'm just kidding. But yeah, a living trust is the best way to avoid probate.
I see.
Some people think the way to avoid probate is to add a child onto a property as a joint tenant, or put a child onto a bank account as a joint signator on the account. And they think that that's going to avoid probate. But the problem with that is if the child is sued, or if the child has a tax lien or a marital debt or problem, their creditors could come and place a lien on your own home. And all you were trying to do is avoid probate by adding their name on. So people do funny things to protect their legacies, and they end up jeopardizing the legacy. So in the end, a living trust is probably the best way to protect it.
Very good.
Well, America's population is aging rapidly, and except for us, of course, we're just getting better and better. So, but healthcare is becoming a bigger problem and a bigger concern. What type of estate planning documents should be put in place to help with healthcare and medical decisions?
Well, in California, we call that document an advance healthcare directive.
Okay.
And with a little luck, all of us will always be in charge of making our own personal medical decisions. And when you want something, you tell your doctor what you want, even if you're in the hospital.
Okay.
A nurse or a doctor comes into your room and they ask you what you want, and you tell them. But for close to 20% of Americans, there comes a point in time, usually with advanced age, but it could be with an accident or something, where that person can no longer articulate what they want. And without someone in charge, then bad things can happen. Incorrect decisions can be made. But if you have an advanced healthcare directive, then you can choose a person, a spouse, a loved one, a child, who can make medical decisions for you in that situation.
Okay, so will it also cover the end of life decisions, artificial life support? Is there a document to protect someone from being on a machine like a vegetable?
Yep, that's right. Actually, in the Advanced Healthcare Directive, there are provisions that you can elect that indicate to the family that you do want to be hooked up to a machine, regardless of the cost or the duration, because you're hoping that maybe in 100 years they'll be able to resurrect you or solve the medical problem. Or alternatively, you can, like most of my clients, elect to not be put on a machine. And the typical provision says that if two doctors, two licensed physicians, both certify that you are in a persistent vegetative state, if that situation exists, then they will unplug the machine and allow the patient to either recover naturally or expire naturally. So that's it's called a right to die document or a living will, not to be confused with a living trust. But those terms are in the Advanced Healthcare Directive.
Okay, and a living will. I was going to say, what kind of estate planning document this is can help a person with financial decisions if they become incapacitated? That's a living.
That's a durable power of attorney.
Okay.
That we typically, actually you can have provisions in your living trust too, Wanda, that do say that if I lose my marbles and I can no longer function or sign checks to pay bills, my designated trustee on my living trust can handle all of my trust assets. All of the assets that are in the trust, if I'm incapacitated, my trustee handles the business. But many people have assets that are outside the trust. Sometimes they have checking accounts or an IRA or a 401k, or they have another financial matter like a tax return that needs to be signed. And the living trust can't do it because it's a non-trust matter. So for those out of trust financial decisions that need to be made in the event of incapacitation, we use what's called a durable. It's actually a springing, durable power of attorney. And it springs into effect if and when I become incapacitated, again, according to two doctors. And then the person that I choose, if I choose you and I get Alzheimer's, you can start signing my tax returns without having to go to court and create a conservatorship, which is what they call a living probate. So.
Well, is there anything that a family with young children should do to protect the kids and make sure that the right person will be in control if the parents die and leave minor children?
Absolutely. There's a big misconception that estate planning is only for the elderly. Now, we're all going to be old at some point, if we're lucky.
Amen.
But for many folks, they need estate planning because they have minor children.
Right.
And the proper document to have created is what's called a will. And in the will, you need to designate guardians for the minor children. So for all those folks out there that have young children under the age of 18, they should have a living trust to avoid probate, but they should also have a separate will. And in the will, they should designate the family members that they want to raise the children in the event that the parents pass away and the kids are still under the age of 18. And you can choose a guardian of the person. That's the person that's going to wash the clothes and prepare the food and drive the kids to school and raise them. And you can also designate in the will a guardian of the estate, the person that's going to handle the finances. And they can be the same person or they can be different people, but it's very important for younger families to have an estate plan in place and designate guardians for their kids. Otherwise, it becomes a decision for the public court.
My goodness.
And that's a mess.
Well, in today's economy, most people don't feel too wealthy. Should your average American be worried about the estate tax?
That's a good question. Historically, people that have had large estates worry about paying the estate tax. And the estate tax is a tax levied on the wealthy, and it's about a 50% tax, generally speaking.
Wow.
And this year, your heirs don't have to pay estate tax unless you die and your estate's more than $5 million.
Wow.
So you would have to be fairly wealthy this year. Next year, the exemption is also $5 million. But in 2013, on January 1st, 2013, if you're lucky enough to live past the cataclysmic 2012 when the world is supposed to end, if the world doesn't end and we go into 2013, that maximum amount drops back to $1 million.
Oh.
So anyone in the state of California that has more than $1 million, they might not feel wealthy, but they will be considered by the IRS to be super rich, and they will have to pay up to a 50% tax.
Wow.
So the answer is yes. Even if you don't feel rich, you should be very worried about the estate tax, because after 2013, it's only $1 million. Everything over $1 million is taxed at death, within 9 months after death.
So what can be done to protect the family from estate tax?
Well, first of all, you should try to spend all your money so you don't have anything left when you die. Don't worry about leaving it to the kids because it's your money. But I guess the truth is most people can't spend all their money. So number one, get a living trust, and that can double the maximum protection. If you're married and you get a living trust, you can now pass twice as much without estate tax. And beyond that, if that's still not enough, then we use advanced estate planning tools like life insurance trust, grant or retained annuity trust, private foundations like the Bill and Melinda Gates Foundation or the Warren Buffett Foundation. Those are large foundations, but even regular families create foundations to protect their estates and their legacies from estate tax.
Very interesting. It's good to know.
So what can be done to protect a person or their family from being sued by creditors if they own rental properties and there's a lawsuit related to the property?
Well, I usually recommend to my clients that if they have income properties, they create a limited liability company, an LLC or a corporation, to own the land and create a shield.
Okay.
So that if there's a lawsuit, it's your company, your corporation that's getting sued, not you.
Oh, good. That's really good. Is there anything that can be done to protect a person or their family from being sued if creditors, if they operate their own business?
Now, once again, a lot of folks run their business as a sole proprietorship. They're the owner. If there's a lawsuit, they get sued. So if you're running a business and there's any kind of potential liability, I would once again recommend operating as a corporation or a limited liability company.
Okay, a living trust, it's important to avoid probate and protect privacy. So how does a person go about getting a living trust and of any of these other documents set up?
I would recommend finding an attorney that specializes in estate planning and going to meet with them, have a private consultation, see what the attorney recommends, and then have that attorney prepare the documents. There are some online services that people try to use, but in my experience, they're never done correctly, or they're incomplete, or they don't pick the right kind of trust. I do think, and I'm not just saying this because I'm an attorney, but I do think it's best. It's complicated enough when you consider separate property and community property and the proper titling of all of the assets that you see a lawyer to get it done.
Okay.
Okay, once you have a living trust, how do you make sure that your assets are properly funded into the trust?
Oh, yeah.
Well, this is what's typically overlooked. It's one thing to create the trust, and it's a nice document, and you sign it, and it's notarized, but then you have to pay attention to how the assets are titled, and you have to transfer title. If it's a property, we create a grant deed, and we convey or title the property into the trust. If it's a bank account or an investment account, you retitle that account in the name of the trust.
Oh, that's good. How do you go about choosing someone to manage the trust for the benefit of the family?
A lot of people have a difficult time selecting their trustee. That person is going to take over if you're incapacitated or if you pass away. So you want it to be someone who's honest, someone who's financially responsible and experienced, and it can even be a beneficiary or a family member.
Okay. So if you have a living trust, does it affect the way you file your annual income tax return?
Fortunately not. If you have a living trust, the tax identification number for the trust is your Social Security number. So you and the trust are one and the same. And so no, a living trust doesn't affect the way you file your taxes. You'll just file your regular 1040 tax return each year.
Okay.
No return for the trust.
So where should you keep your trust or your wills and the durable powers of attorney and so forth?
Well, I recommend you keep it on your coffee table in your home, so when your guests come over, they can see if they're a beneficiary or not. You have your VIP list right there. Actually, a lot of clients ask me that question.
Okay, I was going with it. I was like, no.
I mean, you could if you wanted, but in most cases, you want to make it a private document.
Okay.
Keep it at home in a safe place, maybe in a safe, or in the bank in a safe deposit box. It's okay to let your attorney have a copy, but keep it private.
Okay. Should you give a copy of the living trust to your children, or does it say to give a copy to your children, or what do you do?
I like the idea of keeping everybody on pins and needles until you're gone, and then they can find out who was good and who was bad.
Really?
No, you know, I'm joking again.
Okay.
It's a very personal decision. I think you can, if you want to, you can give your kids a copy, but you're under no obligation to do that. It's a very personal decision for each person to make. It's okay to give them a copy and even sit down with them and say, look, this is what we've done. We want everyone to know about it. Or if you want to keep it completely private because it's really your business, that's okay too. So it's a different decision for everyone, I think.
Mr. Hales, thank you so much for being on the show. Thank you for coming out from Orange County to be here with us, and hopefully you'll come back again and we're going to pick your brain some more.
I'd be glad to.
Join us next week on From the Halls of Justice.